Which begs the question, why would an officer ever let anybody out of the vehicle if they can broaden their ability to search these individuals by just simply making him stay in the car?
Hey everyone, I have got something They sleep until I decide to do something, then there's dogs everywhere. I just want to give you a little bit of quick background on this case because what we're going to hear is a motion to suppress, and it's a little too much to put in text because they don't really cover what happened and how it led up to this, just a little bit, but not enough. So this happened in Butler County, Kansas, back in January, and one of the sheriff's officers conducted a traffic stop on a vehicle that failed to yield. Another officer responded to the scene, so there was 2 officers on scene, and there was 5 occupants in the vehicle. And the driver was discovered to have a suspended license and no proof of insurance, so he was taken into custody. At some point in time during the traffic stop, one of the officers was actually a canine officer, where he was in charge of the canine officer because the canine's actually an officer too. So the canine was walked around the vehicle and hit on the vehicle. At that point, they took everyone out of the vehicle, and it's alleged that when the passengers were ordered out, Ms. Sizemore, who is the defendant, asked to take her purse with her and was told to leave her purse in the vehicle. The detective specifically said everything stays in the car, which included her purse. So the whole controversy here is a woman's purse allowed to be taken out of a vehicle with her, or is that part of the search of the vehicle? And there's a good bit of argument back and forth and some case law on whether that's allowed or not. So I'm going to let you get to it, and you're not going to hear me again. So everybody have a fabulous day. See you soon.
This is in the District Court of Butler County, Kansas. Case entitled State of Kansas versus Christina Lynn Sizemore. Case number 2023 CR 11. Brett Sweeney appearing for the state of Kansas. James Watts' defense counsel. Defendant Sizemore now appears in the office of her attorney, James Watts. This matter comes before the court at this time for hearing on a motion to suppress evidence. Mr. Sweeney, do you intend to present evidence at this hearing?
Your Honor, I've been kind of going back and forth on that because I think the facts are largely undisputed on both sides. I don't know. I may call Deputy Nitcher for just very few questions for a few things I want to establish.
Very well. Deputy Nitcher, you can join fully with audio and video.
I'm here, Your Honor.
Okay, very good. I'm going to administer an oath to you at this time. If you'd raise your right hand, please. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
You may question the witness, Mr. Sweeney.
Thank you, Your Honor. Sir, would you please state your name for the court, please?
Be Deputy Caleb Nitcher.
And Deputy Nitcher, who do you work for?
The Butler County Sheriff's Office.
And Deputy Nitcher, how long have you been a law enforcement officer?
7 years.
Okay. And I'm assuming in that course of your employment with the Butler County Sheriff's Office and also as a law enforcement officer that you had the opportunity to investigate and work traffic cases?
Yes.
How about drug cases?
I have.
Okay. I want to direct your attention, Deputy, to January 10th of 2023. Were you on duty and acting in capacity as a Butler County Sheriff's Officer on that day?
I was.
Okay. And officer, specifically at 10:49 a.m., can you tell me where you were located and if you had the opportunity to conduct a traffic stop?
I was on US 54 in Butler County, and I did conduct a traffic stop on US 54, westbound lane.
Okay. And talk to me a little bit about, I guess, why you pulled the vehicle over and then if you made contact with the occupants of that vehicle.
Yes. So we were traveling westbound, and what I noticed was the vehicle went from the left to the right lane without engaging its turn signal. And when it returned to the left lane and passed a semi-truck and trailer, after the vehicle passed the semi-truck, it turned to the right. It turned to the right using its signal immediately. causing the semi truck and trailer to lock up, causing the brakes. So almost caused an accident.
Okay. And I'm assuming then you pulled over the vehicle.
Yes, I did.
Okay. And I'm going to kind of try to cut right to the heart of the issue. I'm assuming you made contact with the occupants of the vehicle. How many people were inside this car?
There were 5.
Okay. The driver, what was his license status?
It was suspended.
Okay. Did the vehicle have insurance on it?
At the time, no. Vehicle insurance was later located. Someone sent it through a cellular device.
Okay. But at the time, he wasn't able to provide insurance?
No.
Okay. What were your intentions with the driver of the vehicle?
He was going to be going to the Butler County Adult Detention Facility for driving while suspended.
Okay. You were also the canine officer, is that correct?
Correct.
Okay, so you had the canine officer in your patrol vehicle with you?
I did have the drug dog in my vehicle.
Okay. At what point did you run the drug dog around the vehicle?
It would be before arresting the driver for driving while suspended. I left them in the vehicle.
Okay. At some point, did the drug dog hit on the vehicle?
Yes, the dog alerted to the odor of illegal narcotics when I deployed her at 11:04 hours.
Okay. Were the occupants of the vehicle left inside the vehicle during the running of the drug dog? And if so, why?
Yes, they were. It was a safety precaution with me and one other deputy on scene. There were 5 occupants. And I actually went up to the car and asked them to roll the windows up for that safety precaution as well, because the dog is a patrol dog, which has the potential to apprehend suspects. So for the safety aspect, I had them roll the windows up and stay in the vehicle.
Okay. Did you ask any of the occupants of the vehicle, I guess specifically Ms. Sizemore, for consent to search the vehicle before you ran the drug dog?
No, I did not.
Okay. And I'm assuming that once you got a hit on the vehicle, did you consider that to be probable cause?
Yes, once Deputy K9 Zena alerted to the vehicle for odor of illegal narcotics, showing that positive alert by sitting down, I know from my training experience that I have probable cause to search the vehicle.
Well, probable cause and exigency, or just probable cause?
I'll need an education on that.
I'll just withdraw that question, Your Honor. That's probably beyond the scope of his training and experience.
Very well, Mr. Sweeney. Please continue.
Okay. So what was your next course of action once you had the drug dog alert on the vehicle? What were you going to do?
So I requested additional units due to the sense that there were 5 people in the vehicle and 2 of us on scene. When more units started showing up, we placed them in a detained status where they were detained for pending search of the vehicle because we had probable cause.
Okay. Now, I specifically want to direct your attention to any conversation that you may have had with the defendant, Ms. Sizemore. When she was ordered out of the vehicle, can you talk to me about any conversation that you may have had with her?
I don't want to say any comments specifically or in quotations due to it being so long ago, but when we have them exit the vehicle, she did have a purse and we asked that the purse stay inside the vehicle. There was weapons in the vehicle prior, and I actually observed them on my initial approach. So for the safety portion, we just had to ask them to leave everything in the vehicle.
Okay. I mean, you've been a law enforcement officer for 7 years. Is it a possibility that drugs could be contained in that purse as well?
Yes, it is a very strong possibility, as well as on the person, which later under Miranda, she had a meth pipe in her bra and she admitted and retrieved herself.
Okay, but this is after the search.
Correct. This is after this.
Okay, and Deputy, I just want to make sure that I have everything correct in the sequencing. At no point before the establishment of probable cause did she ever assert any privacy interest in that purse or anything, did she?
No.
Okay. And I'm assuming it's just like a over the shoulder purse with a long strap, something like that. Like to the extent.
I don't want to put in test. Yeah, it was a purse. I don't want to get into the extent because I don't want to say something incorrect.
That's fair. That's fair. And she had it and was trying to leave with it when you told her to leave it in the vehicle. To the best.
Yes, yes, the best of my ability of recollection. She tried to get out with the purse, but everyone was being detained at that point in time because of probable cause.
Okay. And then I'm assuming the purse was left in the vehicle.
Yes, it was.
And then you searched the vehicle.
Yes.
Your Honor, I think for purposes of what today's hearing is, that kind of covers everything that I really needed to establish.
Mr. Watts, any further questions for the deputy? You'll need to unmute yourself, counsel.
Your Honor, I'm having a moment here. I was listening to the deputy's testimony and I have the video from what's as K White in front of me. I'm trying to find the section in here, and I know I watched it. I watched it with my client where the drug dog is walked by the car. Well, let me ask the questions, Your Honor, and I'll see if I can find it.
Okay, you may continue.
Officer, have you watched the body cam of what is labeled as K White video 1?
I have not. That looks like that'd be Deputy White.
Okay.
Put up on scene.
And Deputy White is at that scene, correct?
Correct.
And at that scene, I know you can't see this, but I'm sitting here watching the video and I'm counting at least 4 separate officers at that scene. Is that incorrect?
I don't want to give a bad testimony. I can't remember the number of officers on scene. I know that we had plenty of officers show up. You are correct. There were, I think, 4 officers at some point, but I don't want to give you an incorrect answer.
Well, the reason I asked that is, and again, I have watched this with my client sitting here in the office, is that video, K White 1, also includes the dog walking down the car. We noticed it was unusual because the occupants were left in the vehicle, correct?
They were.
And your testimony that the officers were left, the persons were left in the vehicle because there weren't enough officers to assist and keep everybody basically controlled.
Control is a pretty strong word, Mr. Watts, I would say, but I see what you're saying of officer to citizen ratio for safety issues.
The reason I'm kind of hesitating here because I'm trying to skim through this video as I talk to you. I'm trying to find the spot in this video where the dog sniff is actually done to remind myself of when it takes place. Okay, well, Judge, I'm not going to take the court's time to try to review it again. It runs about 10 minutes long, and I don't know that it's all that relevant in the first place. What's important here, the occupants of the vehicle were left in the vehicle as the dog does the sniff. Correct?
Correct.
Okay.
Correct.
That is not the usual practice, is it?
It's situation dependent. There is no case law that says they can be in or out of the vehicle. It's situation dependent. The department.
I'm aware there's no case law. The case law on dogs is that dogs are magic and whatever the dog says goes. But the common practice in nearly every case is to remove the occupants from the vehicle. I can count on one hand the number of times I've seen a dog sniff where the persons are left in the vehicle and have fingers left over.
Again, that is situation dependent.
I don't think I have anything else, Your Honor. Thank you.
All right. Anything further for this witness, Mr. Sweeney?
No, Your Honor.
All right. Deputy Nitcher, you can stay with the meeting or leave it at your choice. If you do stay with
Yes,
the
Your
meeting,
Honor.
I
Thank
would
you.
ask you to mute yourself.
Yes, Your
Okay.
I know that's it.
You have further evidence to present, Mr. Sweeney?
No, Your Honor.
All right. Counsel, I'm aware of defendant's motion and essentially brief in support of the motion to suppress and the state's brief in opposition to the defendant's motion to suppress. I've also had an opportunity to review some of the case law that has been specifically cited by counsel in their various submissions to the court. So at this time, the court would entertain oral argument in respect to your various positions. Mr. Sweeney?
Yes, Your Honor. So, like I said previously to the court, I don't think the facts of this case are largely at issue. I mean, I think it just is an issue of where this case falls in the intersection between all of these cases that involve purses and essentially the exception to the warrant requirement that applies here. So obviously, it's not a search incident to arrest. And I think the place where this can be differentiated from Boyd is essentially that we're not dealing with a consent search. So obviously a consent search can be limited as broadly or as narrowly as the suspect wants it to be. That can be absolutely outright revoked. But that's not what we have here. I agree that if there was some statement that was made by Miss Sizemore to Deputy Nitcher or one of the other officers on scene prior to the establishment of probable cause, then surely we would have been in violation of the Fourth Amendment. However,
What statement would you expect her to make, Mr. Sweeney? She's a passenger in a car that's been stopped. She's supposed to roll down the window and holler at the officers, "I'd like to assert my Fourth Amendment rights to my purse"?
Well, at some point, presumably, Your Honor, when the Officer Nitcher or any of the other officers are kind of detailing and chronicling what the situation is, including the suspended nature of the driver's license, the window would have been down. She could have had the ability to speak up at that point. But I get it. Maybe there's a limited opportunity for her to do that. But in the grand scheme of things, I don't know that it matters once the establishment of probable cause is made. Because once the establishment of probable cause is made, Your Honor, I think that the case law is pretty clear. And I think this is established through Houghton, I'm not sure how to pronounce that, Supreme Court case, and then also Ross, which is cited in my brief. But it's pretty clear that any container that could contain the contents of what the probable cause is for, and in this case it's drugs, and the testimony is pretty clear, and the court, I'm sure, is well aware, could be found inside a purse. Once that establishment is made, those items are left inside the vehicle. Now, Boyd, I would concede, is a bit confusing, and it's kind of talking about purses, and maybe there's some sort of additional privacy protection as it relates to purses. But certainly, I think our case can be distinguished from Boyd. Hold on, let's see exactly where. Put it here. So Boyd, the interaction in Boyd, so that the consent interaction, whether or not that Boyd is going to consent to the search of the vehicle, she objects before the establishment of probable cause. And that's the key, Your Honor. Once we hit that portion where probable cause is established, I think the case law is pretty clear. And then it's also, I think, pretty clear in Grosjean as well, that if you've got probable cause, okay, any conversation about whether or not consent to search the purse or search the vehicle kind of ends right there, because you've already established probable cause. And so I think it's really the conflation here of two warrant exceptions, consent versus probable cause with exigency. Of course, we have the exigency. And I think this is really just a conflation of the two, and try to make the water a little murky, but I think it's pretty clear, given Deputy Nitcher's testimony, and I think what's agreed that the facts are in this case, that there was no objection, no consent. So we're dealing solely with the probable cause exception of the warrant requirement. And if we have that, I think you're in.
All right. Mr. Sweeney, I understand your analysis, but here's what troubles the court. The officer made a discretionary call in this case not to remove the passengers from the vehicle during the drug dog sniff, which is consistent with generally how this is done. I don't know if it's limited to just the number of fingers on Mr. Watt's hand or not, but nevertheless, it does appear to be a rarity that they leave everyone in the car while this drug dog sniff is going on. If he simply removes the passengers from the car, which is commonly done, are you arguing that he would still be able to use this probable cause determination based on the sniff to search the passengers and their purses standing outside the vehicle?
I am not, Your Honor, but I
Okay,
think
so if the officer pins the people in the car and doesn't let them leave it, they have less rights than if they are allowed to leave it. Is that correct?
I would say no, Your Honor. I mean, I think we're speculating as to what her response would have been if he asked for them to step out of the car so he could run the drug dog around the vehicle. I mean, I think
Okay. But let's presuppose that she would have done what she did anyway. She would wanted to take her purse with her. She and her purse would then be outside the vehicle. And are you saying that because the drug dog alerted on what was left in the vehicle, then you could search the passengers who were outside the car at that point and their personal effects, such as their purse?
I do not believe at that point, barring some personal safety exception on the part of the officer, which the officer I think actually testified to today, although that was, I guess, somewhat of a surprise to me. But no, I would say no, barring some sort of safety cursory search outside of the vehicle, to the extent that answers the court's question.
Which begs the question, why would an officer ever let anybody out of the vehicle if they can broaden their ability to search these individuals by just simply making him stay in the car? Does that seem fair, that discretion can be exercised to give law enforcement a greater power to search citizens than they would have if they let them get out?
You know, I mean, I don't know. I guess
that's the importance. He made the call, not Miss Sizemore. He didn't give him an option, and she said, "Well, I think I'll just sit in the car." Maybe it's cold outside in January, and she just wanted to sit by the heater. Then it's her call to stay in there. But in this case, the law enforcement officer made the call requiring them to stay in. So anyway, go ahead, Mr. Sweeney, if you had some additional remark.
No, Your Honor, I appreciate the court's allowance, but Your Honor, I think every situation is fact dependent. As Deputy Nitcher testified, certainly there's been instances where, and I think this is also for safety purposes too, sometimes where they're ordered out of the car. So, you know, potentially a suspect can't, and another officer stays with them, so a suspect can't approach them from their back. In this situation, there's a lot of individuals in the car, and maybe more than what you might normally see. So 4 or 5 individuals in a car, they're ordered to stay in. I don't know the ratio of how often that happens, but I mean, I would say it's fact specific. And I don't know that it certainly didn't sound like from the deputy's testimony that subjectively he had any intent to lessen the suspect's privacy interests in any way by doing this. It didn't sound like he had gone through that calculation in his mind. I think if the passenger would have said something to the effect of, "Hey, I have a privacy interest in my purse," and I now understand that's an odd thing to say, but that may have changed the calculus. But that wasn't said, and that didn't happen, and probable cause was established. And then the conversation happens. And I think the case law that we do have tends to say that that's kind of where the conversation ends. And that'd be my argument, Your Honor.
Mr. Watts, do you agree with Mr. Sweeney's analysis?
I do not, Your Honor, and it will surprise no one to say that I view this with much more cynicism than Mr. Sweeney does. It is my suspicion that the officer does it with the dog, with the people in the car, precisely so that he can search everything in the car, including what they have on them. These searches and the way these searches are conducted do not happen in a vacuum. And despite what Deputy Nitcher says, this wasn't about officer safety. This is about making sure we can search everything. And I say that because I just found it at 11:04 on Officer White's video. The first video is the officer walking down the driver's side of the car. There are at least 4 officers present there, counting the 3 I can see on camera, plus the one who has the camera on his chest, the one carrying the camera. Obviously, I can't see him. So despite the officer's assertion, there are plenty of officers there to keep track of everyone. But for whatever reason, they decide to keep people in the car. My suspicion, and again, I'm a cynic, is that law enforcement has figured out that if they leave people in the car, they get a broader search. In fact, the Boyd court itself foresaw that coming. And I'll note in my brief on page, where is it? On page 5 of my brief, page 283, the Boyd court notes that in order to get around the rule, the Boyd court could simply order passengers to remain in the car and thus make their persons subject to search. It's rather prescient that the Boyd court foresaw this very thing happening. Interestingly enough, and the very next sentence of the motion as I look at it, if this was a man's wallet, we wouldn't be having this conversation. And that serves essentially the same purpose as a woman's purse. My wallet, as I'm sure your honors, my life is in here. Your driver's licenses, your credit cards, everything that you have, your personal stuff. This is how, for most males, we carry it around. These days, we add to that this, our cell phone. For most men, though, our lives are in those 2 items we can stick in our pocket. For most women, for whatever reasons, and I was discussing this with Stephanie, in large part, I suspect because women's clothing simply doesn't have a lot of pockets. Women carries in a purse. The purse is this for a woman. And the Boyd court recognizes that. This court does not decide this case on the basis of whether probable cause has existed or where some fine line probable cause had existed. It decided this case on the basis of the inherent privacy of our personal items, whether it be our wallet or our purse, or I suspect these days, our cell phone. This is different from just the vehicle. And as I said, I'm a cynic. I suspect this dog sniff is done exactly for that purpose, and so you can make sure you can search everything in the car. The state cites Groshong. The problem with Groshong, of course, and why Groshong is, I think, well, you've got my motion. Groshong, I think, is easily distinguished from this one on its facts. This is a very different case than Groshong. In Groshong, the woman had gotten out of the car, left the purse. Probable cause was later established. And then after everybody knew we're going to search the car, she says, oh, wait, I want to go back and get my purse. That's not what happened here at all. At the very first indication, my client attempts to take her purse out of the car. And there's really no dispute that that's the case. She doesn't leave it behind. She doesn't know. I don't know whether she knows probable cause exists at that point or not. She's told that everybody has to get out of the car, and she's told to leave her purse there. The one thing that struck me as I listened to Mr. Sweeney is, again, and I won't get the quote right, the line from Justice Breyer years ago. The courts and the public and the police expect way too much chutzpah from the citizens to try to understand these fine lines and assert their rights. The courts have a habit of drawing these fine lines and asserting that if something happens on this side of a line, it's one way, and it happens on this side of a line, it's another way. And we draw our cases based on those fine lines. Public doesn't understand those fine lines. They don't understand, nor should they be expected to understand the intricacies of probable cause, when and where probable cause might exist, and what the limits of that probable cause are. We don't even agree on them after research and briefing. How do we expect the public to understand those rules? They can't. And to be perfectly blunt, law enforcement relies on the public not understanding those rules, and they take advantage of it, which is why we walk the dog down the car with the people still in it. So, Judge, I think that the distinction whether the probable cause had existed or not is a false distinction. The distinction here is very simple. That purse is her very private personal property, much like your wallet, Your Honor. And the case law, Boyd, says that she asked to take it out, and she asked to take it out at the first instance. You don't get to search it. And that's what she did here. And setting that line on where, to be perfectly blunt, law enforcement decides to place the probable cause distinction is asking way too much of the citizen in dealing with law enforcement. I think this should be suppressed.
Very well. Thank you, Mr. Watts. Court is going to refer some specific excerpts from State versus Boyd and State versus Groshong in making its decision here this morning. I appreciate the conciseness and clarity of both arguments in the case. I understand each of your two positions quite well. First of all, from State versus Boyd, page 282. There is no question the purse was Boyd's personal property, in her possession and under her control. She attempted to take it with her, but was directed to leave it in the van. Under these circumstances, her purse was entitled to the same increased protection from search and seizure as afforded to her person. The search of Boyd's purse violated her Fourth Amendment right to be secure in her person and effects from unreasonable search and seizure. Further, as Mr. Watts referred to earlier, the specific quote from page 283. If we hold an officer can lawfully order a passenger to leave her purse in the car and thereby making it subject to search, then what prevents the officer from ordering the passenger to remain in the car, thus subjecting her to be subsequently searched along with the car? The protection of the Fourth Amendment cannot be defined at the discretion of the law enforcement officer. The heightened privacy interest and expectation in the present case is sufficient to tip the balance from governmental interest in effective law enforcement, which outweighed the privacy interest in Houghton when the purse was voluntarily left in the back seat unclaimed. We hold that where a passenger is told by a police officer to get out of a lawfully stopped vehicle, and in response to the officer's order to leave her purse in the vehicle, puts the purse down and exits the vehicle, a subsequent search of the purse as part of a search of the vehicle violates the passenger's Fourth Amendment right against unreasonable search and seizure. The motion to suppress should have been granted. In considering the probable cause argument made by the state, the court understands it. The court would refer to State versus Groshong and a specific quote made by the Kansas Supreme Court in that case. It analyzed case law from the Florida and Idaho court systems. And they state, the Florida and Idaho courts have heeded Justice Breyer's warning to avoid subjecting a passenger's purse to a search during the lawful search of a vehicle. A passenger in Florida and Idaho must immediately assert a privacy interest in the purse by taking it upon exiting the vehicle. Quoting Hawley from Florida and Holland from Idaho. The next line from our court is, we agree with the Florida and Idaho courts. In other words, they agree that even during a lawful search of the vehicle, if the passenger takes their purse with them and therefore immediately asserts a privacy interest in that purse by immediately taking it upon exiting, then they have a right that cannot be violated by requiring them to leave that behind. That's what happened in this case. This court holds that when the passenger, Ms. Sizemore, was told by the officer to get out of a lawfully stopped vehicle, and in response to the officer's order to leave her purse in the vehicle. She puts the purse down and exits the vehicle. The subsequent search of the purse as part of the search of the vehicle violated Ms. Sizemore's Fourth Amendment right against unreasonable search and seizure. The motion to suppress, therefore, is granted by this court. Now, Mr. Watts, Mr. Sweeney, it's the court's understanding that the pending charges in this case are possession of methamphetamine ostensibly found in the purse and possession of paraphernalia for use ostensibly also found in the purse, or stemmed from what was found in the purse. Correct?
I think in both cases, Your Honor, those items are found in that purse.
Do you agree, Mr. Sweeney?
I do, Your Honor.
That evidence has been suppressed. It would appear appropriate for this court to dismiss the criminal case against this defendant. And the court makes that order. Ms. Sizemore, do you understand what happened here today?
Yes, I do, sir.
All right. Due to what the court ruled in your favor, the evidence against you has been suppressed. In other words, it can't be used by the state. That's what we call the
They can't bring it
exclusionary
back
rule.
up, right?
Excuse me?
It's not like a walk charge where they can bring it back up, correct?
Oh, they can't
Okay.
refile the same case on the
Okay.
same facts. No.
I've never been in trouble, so that's why I was wondering.
Okay. So my next statement is this essentially concludes the prosecution against you in this case. The state does have a right to appeal, which may lengthen the pendency of this case. But nevertheless, at this point, there is no more active prosecution against you pending in the court at this time. Therefore, you have no further court appearance requirements in this action at this time.
Okay.
Okay? With that said, I hope, Ms. Sizemore, that this has been a horrible experience for you, that you've really come to grips with the fact that methamphetamine was found near your person. Methamphetamine is an incredibly dangerous drug, and there's nothing positive about it. There's nothing positive about methamphetamine culture. While you're no longer subject to the orders of this court, at least at this pending time, I hope that you have completely separated yourself from methamphetamine and anybody who would expose you to it. Your life will be a lot better without it. Good luck to you, Ms. Sizemore.
Thank you.
All right, make sure you thank your attorney for a job well done as well. All right. Gentlemen, attorneys, is there anything else the court needs to address on the record here?
No, Your Honor, nothing I'm aware
No,
of.
sir.